Assalamualaikum. Today our group will present about reflective essay on information ethics and law. This is our group members: FARAH NAJWA binti GHAZALI, NURULHUDA binti KAMARUL ZAMAN, FAZLINA AMIRA binti MOHAMMAD FAZLI, and HANI binti HAMZAH. 1.0 Introduction. In the digital age, information is a valuable asset. It drives decisions, innovation, and development at every level. Digital technologies have reshaped how we create, store, access, and share information. But this digital shift also introduces new risks, including data misuse, privacy breaches, and ethical gray areas. As a result, ethics and legal frameworks have become critical for governing and protecting the use of information. Understanding these two elements is essential for anyone working with data, especially in a professional or organizational setting. Challenges in the digital age. With digital technology becoming embedded in daily life, boundaries between personal, organizational, and public data are increasingly blurred. This overlap raises concerns about how data is being used and by whom. It's now harder to balance innovation, for example, using big data for better services, with protecting fundamental rights like privacy, security, intellectual property. The public has grown more aware of unethical data practices, high-profile data breaches, misuse of personal data by social media companies, growing use of AI with little regulation. These issues point to the urgent need for ethical standards and updated legal frameworks to regulate how information is handled. 1.1 Law is primary rules in information use and management. Law acts as a structured, enforceable system to regulate how information is collected, processed, stored, and shared. Legal regulations protect both individuals and organizations by setting clear rights and responsibilities. Key legal functions. Data protection laws, for example, GDPR in Europe, require informed consent before collecting personal data, mandate organizations to keep data secure and accurate. Intellectual property laws protect creations such as writings, software, and inventions, help creators receive proper credit and financial benefits. Organizational compliance. Legal standards help companies avoid lawsuits and reduce risk. They ensure internal policies are aligned with national or international laws. Information security laws compel organizations to protect sensitive data from hacks or leaks. 1.2 The main purposes of ethics and information management. While the law provides formal rules, ethics focuses on doing what is morally right, even when the law is silent or outdated. Key ethical considerations: respect for privacy. Even if legal, collecting data without proper notice or consent may be unethical. Informed consent. Ethics demands that users understand what data is being collected and why. Fairness and transparency. Ethical data use should be inclusive, unbiased, and clear. Avoiding harm. Ethical standards help prevent misuse of information, especially in AI and data analytics. Organizational ethics. A strong ethical culture encourages staff to act responsibly and report wrongdoing. Ethics fills the gaps where the law cannot reach. It shapes how information professionals think, decide, and act responsibly. 1.3 The connection between law and ethics. Law and ethics are distinct but closely related in information management. Many laws originate from ethical principles like fairness, justice, and responsibility. In rapidly evolving digital environments, ethics often leads where the law is still catching up. Key points: when law is outdated, ethical guidelines help decision makers act responsibly. For example, using AI algorithm legally but unethically, for example, bias hiring tools. A legally correct decision can still be ethically wrong, especially if it harms others. Best practices suggest combining legal compliance with ethical reflection to guide responsible info use. Conclusion, ethics and law together create a strong foundation for governing information in a fair, trustworthy way. 1.4 The foundation and importance of ethical information management. Ethical information management is more than just following the law. It's about ensuring data is handled with care, respect, and fairness. Foundations, accountability, define who is responsible for handling and protecting data. Security, prevent data leaks, hacks, or misuse through strong protection. Privacy, let individuals control their personal data and how it's used. Transparency, be open about data practices and allow informed user choices. Fairness, avoid bias and discrimination, especially in automated systems, for example AI. Why it matters? Builds public trust in institutions and systems. Help meet regulatory demands while promoting human rights. Contributes to long-term sustainability, brand reputation, and social responsibility. Final message, ethical information management leads to safe, fair, and inclusive digital environments.
Hello and welcome. In this presentation, we will talk about the regulatory, ethical, and procedure control of information use and management in Malaysia. This discussion is based on four main concepts: law, ethics, standard, and procedure. These four elements are important to make sure information is handled safely, legally, and ethically. For 2.0 overview of control in information management. In today's digital world, information is very valuable. Government, businesses, and even individuals need to manage information carefully. But we discount problems like data misuse, privacy issues, and cyber threat. That's why law, ethics, standard, and procedure work together to guide how information should be used. In Malaysia, these controls are important, especially as the country moves forward with e-government, smart city, and digital economy projects. Each of these four concepts play a different role, but they all work toward the same goal: safe and responsible use of information. For 2.1, what a law, ethic, standard, and procedure? Let's begin by explaining what these four things means. First one, law are officially rules made by the government. In Malaysia, the most important law for data is the Personal Data Protection Act 2010 PDPA. It makes sure people's personal data is not misused. Other laws include the Electronic Commerce Act 2006, the Communication and Multimedia Act 1998, and the Cybersecurity Act 2023, and the New Data Sharing Act 2025. Ethical are more value. They guide people and organizations to do what is right, even if the law doesn't say anything. Ethics in information management focus on things like privacy, honesty, transparency, and accountability. For example, even it is legal to collect someone's data, ethics say you should still ask for consent and protect that data. Standards are agreed best practices. They help organizations manage information properly and consistently. One example is MS 22231-2009, which follow the international standard ISO 15489. This helps organizations manage their record and electronic data in an organized way. Other than that, procedure a step-by-step action that follow law, ethics, and standard. These include how to collect data, how to store it safely, how to report data breaches, and how to give user access to their information. Procedure turn theory into practices. So, simple word, law tell you what you must do, ethic guide what you should do, standard explain how to do it well, and procedure how you actually do it. For 2.2, differences between law, ethics, standard, and procedure. Now, let's look at how these four are different. Law are formal and binding. If you break the law, you can be fined or even go to the jail. Ethics are not enforced by the government, but if you act unethically, you must lose your reputation or job. Standards are often voluntary, but they help ensure quality. If you don't follow standards, your work might be poor and your organization might face audit or lose trust. Procedures are the detailed steps to follow every day. If you skip step or follow wrong procedure, you it can lead to data breaches or operational failure. Each of has a unique purpose. For example, the PDPA law say you need consent before using someone data. Ethics say you should explain clearly why you need the data. A standard might require a encrypted storage for safety. A procedure will describe how to get consent and how to store the data secretly. For 2.3, we will look at the similarity between law, ethics, standard, and procedure. Even though they are different, they also have many things in common. All four aim to protect data and build trust. Law protect people rights. Ethics build trust with user and client. Standard help organization work efficiently and with quality. Procedure make sure everything done correctly and safely. They also work together. For example, a law may require a company to protect user data. The company then use standard to build a strong system, apply ethical value to ensure respect, and follow clear procedure to manage the data. All of them help reduce risk. If any of these four pillars are ignored, it can lead to serious consequences like legal fine, loss of public trust, data leak, and lastly, operational problem. In Malaysia and in other countries, combining these four areas ensures strong information governance. Lastly, we will look at 2.4 summary and visual comparison. Let's summarize these four concepts using a simple comparison. So you will have a four table. The first table is aspect, second information law, third information ethic, four standard, and lastly procedure. So in this table, we will summarize. So in Malaysia, these four pillars are becoming more important due to growing digital transformation. As more data is created, shared, and stored, organizations need to be more responsible. The Malaysia government is also improving regulation like the PDPA, introducing new acts, and promoting ethical government in both the public and private sector. For example, law like the New Data Sharing Act 2025 now regulate how government agencies share data. Ethics are being strengthened through corporate government code. Standards like ISO 27001 ensure cybersecurity is maintained. Procedures are now required in many organizations for breach reporting and data consent. Together, these elements ensure that Malaysia's digital future is safe, trustworthy, and internationally aligned. So, in conclusion, good information governance in Malaysia relies on four key elements, which is law, ethics, standard, and procedure. It has its own rule, but all are necessary to ensure the data is managed in a way that is legal, ethical, secure, and efficient. By understanding and applying this concept, organization can protect user rights, avoid legal trouble, build trust, and succeed in digital economy. Thank you for listening, and we hope this has given you a clear and simple understanding of the key control in information management in Malaysia.
Intellectual property or IP refers to creation of the mind such as invention, artistic work, and brand names which are legally protected. These rights allow creators to benefit financially and prevent others from using their work without permission. The main types of IP include copyright, trademarks, patents, and trade secrets. Copyright is a legal mechanism to protect original work like literature, music, and software. For example, the novel by J.K. Rowling, Harry Potter and the Sorcerer's Stone, is protected by copyright, meaning no one else can legally reproduce or sell the work without her permission. Each country has its own copyright laws with different rules on duration and enforcement. Now let's take a look at the comparison of copyright laws in Malaysia, the European Union, and the United States. While the goal of copyright laws is generally the same, to protect the creator's rights, the implementation differs from one region to another. First, regarding the main law, in Malaysia, copyright is governed by the Copyright Act 1987. The EU follows the EU Copyright Directive and is also part of the Berne Convention, which harmonizes copyright rules among member countries. In the United States, the main laws are the Copyright Act of 1976 and Digital Millennium Copyright Act (DMCA), which focuses on digital content. Next, all three regions offer automatic protections. This means a work is protected by copyright as soon as it's created and fixed in tangible form. You don't need to register it for it to be protected. When we talk about the duration of the protection, in Malaysia, it lasts for the lifetime of the author plus 50 years. In the EU, it's life plus 70 years. And in the US, they also provides life plus 70 years, but it's specifically for works created after 1978. Moral right, which includes the right to be credited and the right to protect the integrity of the work, are treated differently. In Malaysia, they are recognized but with limited enforcement. In the EU, they are strongly recognized moral rights, especially in the right of attribution and integrity, while in the US, they only recognize moral rights in a limited form, mainly through the Visual Artists' Rights Act or for specific types of work. Now, regarding exceptions to copyright, which allow limited use of work without permission, Malaysia practices fair dealing, which is more limited in scope. The EU uses exceptions and limitations, which are generally more restrictive than in the US. The US is known for fair use, which is a broader and more flexible legal doctrine. When it comes to digital protection laws, Malaysia's copyright has been updated with amendments in 2012 and 2022 to address digital challenges. The EU has introduced the Digital Services Act and the DSM Directive to regulate digital platforms and protect rights online. The US enforces digital copyright under the DMC, which penalizes unauthorized online distribution of copyrighted content. Registration is not required in any of the three regions to obtain copyright protection. However, in the US, it is recommended for litigation, meaning it helps if someone wants to sue for copyright infringement. Lastly, the enforcement agencies are Malaysia, MYIPO, and the Ministry of Domestic Trade, EU, the National Copyright Offices, and the European Union Intellectual Property Office, EUIPO, and the US Copyright Office and federal courts. While all three systems protect copyright, their laws differ in duration, moral rights, exceptions, and how digital works are handled. Understanding these differences is especially important in global digital content sharing and creative industries. A trademark identifies and distinguishes a company's product or services. For example, the Nike swoosh logo is a trademark. It helps consumers recognize the brand and prevents other companies from using a similar logo. Trademark laws protect brand identity and reputation in the marketplace. Now, let's take a closer look at how trademark laws differ between Malaysia, the European Union, and the United States. While all three protect brand identity, they have unique regulations and enforcement systems. First, looking at the main law governing trademarks. In Malaysia, the legal foundation is the Trademark Act 2019. The European Union operates under the EU trademark regulation. The United States followed the Lanham Act of 1946, which is one of the oldest modern trademark laws. Next, we have the registration authorities responsible for processing trademarks. In Malaysia, this is MYIPO, short for the Intellectual Property Corporation of Malaysia. The EU manages trademark registration through the EU IPO, the European Union Intellectual Property Office, and in the US, the USPTO, or the United States Patent and Trademark Office, handles all applications. In all three regions, businesses use symbol to indicate trademark status. The TM symbol is used for unregistered marks and the R symbol is for registered trademarks. This is the same across Malaysia, EU, and the US. Now let's talk about the duration of the protection. In Malaysia, trademark protection lasts 10 years and it can be renewed every 10 years. In the EU, it also lasts for 10 years but can be renewed indefinitely. In the US, the term is 10 years with renewals every 10 years similar to Malaysia. In all three regions, registration is not mandatory, but it significantly strengthens your legal position. In the EU, however, registration is required for protection across all member states. In the US, registration is critical if you want to take legal action in court. And it comes to distinctiveness, all three systems require that a trademark be unique, not generic, and capable of identifying the source of goods or services. This helps avoid consumers' confusion and strengthens brand recognition. Another important factor is the use requirement. In Malaysia, the trademark must be used or there must be intent to use it. In the EU, if the trademark isn't used within 5 years, it risks cancellation. In the US, commercial use is required, but you can file based on intent to use first. Finally, regarding the scope of protection, in Malaysia, protection is national, meaning it applies only within the country. In the EU, registration offers protection across all member states, making it very powerful for regional businesses. In the US, trademarks receive federal protection, which applies across the entire country. In summary, while trademark system in Malaysia, the EU, and the US share many similarities, such as the symbols and duration, they differ in terms of enforcement strength, use requirement, and the scope of protection. For businesses operating internationally, understanding these differences is essential to safeguarding their brand identities across borders. Give inventors exclusive right to use, sell, or license their invention for about 20 years. For instance, Pfizer patented its COVID-19 vaccine, allowing the company to profit from their innovation. Patents encourage new invention by offering temporary protection for inventors. The image shows the step to obtain a patent on products that are made. Let's now examine how patents law compare between Malaysia, the European Union, and the United States. While the core purpose of patents protecting invention is shared globally, there are differences in how each system handles patent registration and enforcement. Starting with the main law, Malaysia enforces patent under the Patents Act 1983. The EU operates under the European Patent Convention or PC, which is implemented through the European Patent Office or EPO. In the US, patents are governed by the Title 35 of the United States Code, often referred to simply as 35 USC. Next is Registration Authority. In Malaysia, patent applications are handled by MYIPO. In the EU, the EPO processes applications across participating states. And in the US, the USPTO or United States Patent and Trademark Office is the official body. All three regions grant patent protection for 20 years from the date the patent application is filed. This uniform duration encourages innovation while giving inventors enough time to benefit from their creation. Now let's talk about the types of patents allowed. Malaysia allows patents for products, processes, or improvements. The EU goes a step further by also allowing software patents, but only if the software provides a technical contribution. And lastly, the US allows software patents provided the invention is novel, useful, and non-obvious. Software patentability is an area where we see clear differences. In Malaysia, it is more restrictive and generally does not allow software patents unless they have a technical effect. While in the EU, they permit software patents if they solve a technical problem. And lastly, in the US, they has the broader scope, which is it allows software patents that meet utility, novelty, and non-obvious standards. Regarding the grace period for filing, Malaysia allows a 12-month grace period, meaning inventors can disclose their invention and still apply for a patent within 1 year. The EU has a strict novelty rule, which means any public disclosure before filing will invalidate the patent claim. The US also allows a 12-month grace period after the inventor publicly discloses their invention. Examination is required in all three regions. In Malaysia, a substantive examination must be requested before the patent is granted. In the EU, the EPO in Europe conducts a true examination process through its expert, while the US have USPTO, which they evaluate each application for novelty, utility, and non-obviousness. Finally, on international filing, all three regions are part of the Patent Cooperation Treaty (PCT), which allows invention to file a single international patent application. In Malaysia, the PCT route is available via MyIPO. In the EU, both the PCT and IPO system are integrated for broader coverage. While in the US, inventors can file internationally via the US PTO using the PCT or directly through national application. So, in conclusion, while patent protection is standardized in some areas like duration and filing systems, countries differ in aspects like software patentability, grace period, and examination procedures. Understanding these differences is crucial for innovators working on a global scale. Trade secrets are confidential business information that gives a company competitive edge. A famous example is the Coca-Cola recipe. Unlike patents or trademark, trade secrets don't require registration but must keep secret to stay protected. Now let's explore how trade secrets are handled across Malaysia, the European Union, and the United States. Unlike copyrights or patents, trade secrets are protected through secrecy rather than registration, but the legal backing varies from one country to another. Starting with the main law or legal basis. In Malaysia, there is currently no standalone trade secret law. Instead, protection is based on common law principles and Section 1 of the Trade Descriptions Act 2011. In the EU, trade secrets are governed by the Trade Secrets Directive 2016/943, which harmonized the protection of trade secrets across member states. The US has two key laws, the Defense Trade Secrets Act (DTSA) 2016 and the Uniform Trade Secrets Act (UTSA), both of which offer strong federal and state level protection. When it comes to definition of a trade secret, Malaysia does not provide a formal definition in law, so courts rely on case law to determine what qualifies as a trade secret. The EU clearly defines it as information that is secret, commercially valuable, and protected by reasonable measures, while the US defines it similarly under the DTSA as economically valuable, confidential information protected by reasonable security measures. Regarding the duration of protection, trade secrets are unique because They can last indefinitely as long as the information remains confidential. This is the same in all three jurisdictions, Malaysia, the EU, and the US. Do you need to register a trade secret? The answer is no across all three regions. Protection is automatic as long as the company takes reasonable steps to maintain secrecy, like using confidential agreements or secure storage. But what happens if the secret is disclosed? In Malaysia, once a secret is made public, protection is lost. But in the EU and the US have the same approach, public disclosure and protection. When a trade secret is misused, legal remedies are available. In Malaysia, the remedies include injunctions and damages. True enforcement may be limited under civil law. In the EU, you can pursue injunctions, compensations, and even the destructions of any goods that violate the secret. The US provides strong remedies including injunctions, compensatory and punitive damages, and even reimbursement of attorney fees. Finally, let's talk about the criminal prosecution. In Malaysia, criminal prosecution is possible but only under other laws like breach of confidence. The EU generally treats trade secrets cases as civil matters, though some criminal provisions may apply depending on the member states. In the US, there is a strong criminal enforcement under the laws like the Economic Espionage Act, especially in cases involving corporate theft or international espionage. In summary, trade secrets offer indefinite protection, but only if the secret kept confidential. While Malaysia's framework is more limited, both the EU and US offer comprehensive protection through well-defined statutes, making trade secret management a vital part of modern business strategy. Now, let's take a look at the legal framework that governs the protection of intellectual property or IP. This framework exists at three levels: international, national, and digital. Each plays an important role in ensuring creators' rights are protected globally and locally. First, at the international level, there are several important treaties and organizations. One of the most important is the World Intellectual Property Organization or WIPO, which is a specialized agency under the United Nations. WIPO coordinates global efforts to protect intellectual property, helping countries align their laws and policies. A key treaty managed by WIPO is Berne Convention, which ensures that works of authorships like books, music, and films are automatically protected in all member countries without needing formal registration. Another major international agreement is the TRIPS Agreement, which stands for Trade-Related Aspects of Intellectual Property Rights. This agreement is enforced by the World Trade Organization (WTO) and sets minimum standards for IP protections and enforcement across all WTO member countries. TRIPS ensures that IP laws are consistent across borders, which is vital for global commerce and innovation. Second, we have national laws which are specific to each country. These laws provide detailed rules and enforcement mechanisms for protecting IP within their country's borders. For example, in Malaysia, the Copyright Act 1987 protects the rights of authors over literary and artistic works. Similarly, the Patent Act 1983 safeguards inventions and gives inventors exclusive right to their creations for a set period. These national laws are crucial for creators to claim ownership and take legal action when their rights are violated. Third, we have digital-centered laws, which have become increasingly important in today's online environment. As more content is created and shared digitally, IP faces new threats like piracy, illegal downloads, and unauthorized sharing. In the United States, the Digital Millennium Copyright Act, or DMCA, offers copyright holders a way to take down infringing content online. It includes a notice and takedown system that platforms like YouTube and Facebook must allow when copyright violation occurs. In European Union, the Digital Services Act was introduced to ensure that online platforms take responsibility for illegal content. This law not only protects IP, but also aims to create a safer and more accountable online spaces for both users and creators. Next, let's explore some of the ethical issues surrounding intellectual property. While legal frameworks tell us what is allowed by law, ethics guide us on what is right or fair, even when something might technically be legal. First, we will look at the differences between plagiarism and copyright infringement, which are often confused. Plagiarism is an ethical violation. It occurs when someone takes another person's works and presents it as their own, without giving proper credit. This is common in academic or professional environments and is considered a breach of integrity. Copyright infringement, on the other hand, is a legal violation. It happens when someone uses a copyrighted work without permission from the copyright owner, such as reproducing or distributing it. Copyright infringement can result in legal consequences, including fines or lawsuits. So, while both are serious, plagiarism is more about honesty and ethics, whereas copyright infringement is about breaking the law. Second, we consider the differences between open source and proprietary rights. Open source software is freely available for use, editing, and sharing. It supports collaboration and innovation in communities such as academia or technological development. In contrast, proprietary software restricts access to resource code. The developer maintains control over how the software is used and who can modify it. The ethical issue here is finding the right balance. How do we promote innovation and knowledge sharing without denying developers the right to protect and profit from their work? Finally, we must consider the ethical use of IP in education, research, and media. Students and researchers often need to access to books, journals, and articles, but accessing or sharing this material without proper acknowledgement or licensing, for example, downloading pirated PDFs of textbooks, can lead to both ethical and legal violation. Similarly, media outlets must use copyrighted images, videos, or music responsibly. They often rely on the fair use policies but must be careful not to exceed those limits, especially for commercial purposes. In all these cases, the goal is to respect creators' rights while ensuring access to knowledge. Educational and media institutions must navigate these ethical challenges by using licensed content, citing sources properly, and educating users on IP responsibilities. Now, let's talk about the importance of intellectual property laws and ethics in the field of information management. Whether we are working in libraries, archives, or academic institutions, understanding and applying IP principles is essential. First, let's look at the role of IP in libraries, archives, and academic institutions. These institutions are responsible for making knowledge accessible, but they must do so in a way that respects the rights of creators. For example, a university library can simply scan a textbook and upload it online for students to download, unless it has a license or the usage qualifies as fair use. So, what do they need to do? They must secure proper licenses to offer access to books, journals, videos, and other media. They also need to ensure that any use of the copyrighted materials complies with legal exceptions, like educational fair use provisions. Additionally, these institutions often educate students and staff about copyright, fair use, and how to cite source properly. By doing this, they help promote a culture of respect for intellectual property while still supporting research, learning, and knowledge sharing. We face growing challenges in digital IP management. With the shift towards digital content, piracy, file sharing, and unauthorized distribution have become much easier and more common. For example, people can download pirated ebooks, movies, or software in seconds. Even legitimate content, like a lecture or a song, can be shared or copied without proper licensing. Streaming platforms like Netflix and Spotify have helped reduce piracy by offering affordable legal access, but they also complicate how rights holders track and enforce their IP across various countries and platforms. One of the biggest challenges is that the internet knows no borders. Content uploaded in one country can be accessed globally, which makes it difficult to manage and enforce IP laws that vary from country to country. This means that information professionals must be constantly aware of evolving technologies and regulations to effectively manage IP in digital environments. Now we are entering another major part of the presentation, information and data privacy and security. These two concepts are at the heart of the ethical information management in the digital age. Although they are closely related, it's important to understand that privacy and security are not the same. Let's begin with privacy. Privacy refers to an individual's right to control their personal information, such as their name, identity card, location, or even online behavior. It's about who has access to your data, how it's collected, and how it's used and how it's shared. In Malaysia, privacy is protected under the Personal Data Protection Act (PDPA) 2010. This law outlines seven principles including notice and choice. Individuals must be informed and given options before their data is collected. Disclosure. Data must not be shared without consent. And data integrity, meaning the information collected must be accurate and kept up to date. So in short, privacy is about protecting people's right over their own data. On the other hand, security is about mechanisms used to protect that data. Security involves technical tools and strategies to defend their unauthorized access, theft, loss, or corruption of data. This includes encryption to scramble data so only authorized users can read it, firewalls to block unauthorized network access, and access control system to ensure only the right people can enter certain part of a system. Security protects the confidentiality, integrity, and availability of information, known as the CIA triad in cybersecurity. On the international level, we also have recognized standards and frameworks. The ISO/IEC 27001 standard provides a globally accepted approach to managing sensitive information using risk-based thinking. In this section, we will look at the different types of data organization handle and the security mechanism used to protect that data. Not all data is the same. Some information is more sensitive than others and requires stronger protection. Let's look at the three common types of data. First, personal data. This includes names, IC numbers, phone numbers, and home addresses. Any information that can identify a specific person. In Malaysia, this type of data is protected by the Personal Data Protection Act (PDPA). It is more commonly used in commercial transactions such as signing up for services, e-commerce purchases, or loyalty programs. Next, biometric data. This is unique biological information like fingerprints, facial recognition, retinal scans, and DNA. You have probably encountered this type of data when unlocking your phone using fingerprint ID or Face ID. Because biometric data is highly personal and irreversible, protecting it is especially important. Lastly, financial data. This includes bank account details, credit card numbers, and transaction histories. This kind of data is used in online payments, loan applications, and other financial services. Because of its value, financial data is a top target for cybercriminals.
Next is about social justice, equality and inclusivity in information access. In Malaysia, social justice in information access means ensuring that every citizen, regardless of ethnicity, gender, socioeconomic background, or disability has fair and equal access to information. The government has made progress through inclusive policies like the National IOER, Inclusive Open Educational Resources Policy, aimed at providing learning resources for all, especially people with disabilities, OKU. Despite this, issues such as social stigma, lack of sign language, and inaccessible content formats remain barriers to full inclusion. Next, we go to equity versus equality and bridging the digital divide. While equality offers the same tools to everyone, equity recognizes the need for different levels of support to achieve fairness. In Malaysia, digital gaps are seen in rural and orang asli communities where internet access is limited. Initiatives like Jendela and community internet centers aim to expand broadband coverage and digital participation. Additionally, government websites are being updated with screen reader compatibility and Malaysian Sign Language to ensure better access for the visually and hearing impaired. Legal and ethical foundations in information access. Malaysia's approach is guided by international human rights laws such as the UDHR and CRPD, alongside national laws like the Personal Data Protection Act (PDPA) 2010. However, PDPA currently applies only to the private sector. Ethical principles like the PEPA model, privacy, accuracy, property accessibility, are used to guide fair information handling in libraries, hospitals, and public institutions. Still, privacy rights and digital ethics remain underdeveloped, especially in public service sector. Next, challenges and case studies in information governance. Malaysia faces persistent challenges in implementing inclusive policies, digital illiteracy, poor infrastructure in East Malaysia, and the lack of accessible content for OKU hinder progress. Case studies like the Digital Library Bus in Sarawak show efforts to bridge these gaps, delivering e-books and internet access to remote areas. Meanwhile, UKM has implemented inclusive education policies and hospitals are moving forward digital record systems through privacy concerns remain. And finally, future directions and recommendations. To move forward, Malaysia must strengthen legal protections, expand the PDPA to the public sector, and implement clear privacy and accessibility laws. All digital services should follow Web Content Accessibility Guidelines (WCAG) and be available in multiple languages. Training in information ethics should be mandatory for public service sectors. A proposed National Centre for Information Ethics could lead research, training, and policy development to ensure that digital inclusion becomes a lived reality for all Malaysians. That's all from me.
4.0 Conclusion. Managing digital information requires laws, ethics, standards, and procedures. These four elements work together to ensure information is handled securely, responsibly, and fairly in both public and private sectors. Malaysia's legal frameworks like PDPA, CMA, and the Cybersecurity Act protect personal data and guard digital communication. These laws define what is legal, outline user rights, and create rules to prevent misuse of information in digital environments. Ethics fill the gaps where the law may be unclear or outdated. Ethical principles like transparency, honesty, respect for privacy, and fairness help guide decisions, especially when laws haven't caught up with fast-changing technology. Standards and procedures help turn laws and ethics into daily practices. Tools like ISO 15489 and MS 2223 guide organizations on how to manage, store, and protect information in a consistent and auditable way. Real-life issues like data privacy, intellectual property, and fairness in technology show the importance of ethical and legal elements. These challenges require organizations to not only follow the law but also act responsibly to ensure equal access, prevent discrimination, and safeguard trust. Emerging technologies like AI and quantum computing require flexible and evolving frameworks. As technology advances, new laws and ethical thinking must evolve to handle unpredictable risks and protect society. A balanced approach builds a safer, more inclusive, and innovative digital future. Combining legal compliance with strong ethical values helps ensure long-term trust, fairness, and responsible progress in the information age.